Thank you to everyone who's joining us here today. Once again, we wish our competitors the best of luck, and we thank our judges for joining us tonight. Without further ado, I'm going to turn the competition over to our esteemed judges who will call the case, and then we will be delighted to hear from our competitors. Thank you.
All right, welcome everyone. Can I get a hand or a thumbs up from everybody on screen just to make sure everybody can hear me okay? Great, okay. I'm going to go ahead and call the case. I'm not seeing video. I assume, Emily, that there folks are, I see you okay, in room 101. Sorry, the Hollywood squares keep moving around on me. But it looks like we have some of our advocates with us in room 101, and then one of the competitors is appearing remotely. Great. So good afternoon. Welcome to the Rothgerber Moot Court Championship round. I'm going to call the case. We have before us case number 18-1286, Leslie Mendel versus T&B Incorporated. There are two issues that will be argued. I understand that each issue will be argued for a total of 30 minutes or 15 minutes per side. And I think we can go ahead and get started. I understand Mr. Bruns will be arguing for the appellant. Mr. Bruns, you may proceed. And I'm sorry, Mr. Bruns, before you commence, I am not seeing a clock. Do we have a clock available for the judges so we know our time? Ms. Horowitz?
I believe the students can see the digital clock. I believe it's facing them. Is that correct, Mr. Bruns?
Yeah, it's facing me.
All right, we will just do our best guesstimate then. Please proceed, Mr. Bruns.
Thank you, and good afternoon, Your Honors. My name is Steve Bruns, and I'm here on behalf of the appellant, Ms. Leslie Mendel. And with your permission, I'd like to reserve 2 minutes for rebuttal.
You may.
Thank you. This is a standing case in which this court must determine whether it will close the door on victims of sophisticated data breaches. Ms. Mendel has suffered injury in fact, and therefore has standing to bring her negligence claim for two reasons. First, she faces a heightened risk of identity theft and fraud as a result of the data breach. And second, she has spent time and money to mitigate these future harms. For these reasons, we respectfully request that this court reverse the lower court's dismissal of the negligence claim. Now, as a threshold matter, Clapper's certainly impending standard should not apply to this case. Clapper made clear that plaintiffs who bring a claim of future harm must satisfy the certainly impending or substantial risk standard. And the court in Clapper opted for the more rigorous, certainly impending standard out of concern that reaching the merits of that case could have implicated national security or the separation of powers. And here, we are primarily concerned with whether a private company's negligence has harmed a private individual with no implication for national security or the separation of powers. And even if that certainly impending standard does apply, Ms. Mendel's claim of future harm can satisfy it. The plaintiff's claim in Clapper was not certainly impending because it relied on a highly speculative chain of inferences.
Counsel, let me ask you a question. In your brief, you open and you lean heavily on the fact that your client, Ms. Mendel, is an up-and-coming politician. Should we afford an up-and-coming politician or politicians generally more or less deference with respect to their privacy rights? Or does it matter?
With respect to the standing question, Your Honor, the answer is no. The Ms. Mendel's status as a public figure, as a politician, keys in particular to the amount of damages that we are requesting for the emotional distress that she experienced as a result of the breach. But what we emphasize instead of her status as a public figure is the particular nature of the breach in question here, and two key facts about it. The first is that it involved the compromising of sensitive information such as credit card numbers and social security numbers. And
it's really the potential compromise, right? Nothing's happened to Ms. Mendel, correct?
That's correct.
As we sit here today, nothing has happened to your client, correct?
That's correct, Your Honor.
It's all speculative, it's all potential damages.
It is not all speculative, particularly given the 12B1 standard of review, which requires accepting as true the allegations in Ms. Mendel's complaint.
All right, so she spent $50 or $100 on some private security protocols, correct? And she spent a little bit of time on the phone with the representative. That's it, right?
Yes, Your Honor. In addition to that, however, we are asking for $1.5 million in emotional distress that she experienced, which, as we mentioned, does relate back to the fact that she is a public figure. And to your question about needing to infer that not only was data accessed, but needing to infer that it was stolen, we point to the complaint, and again, reiterate the 12B1 standard of review here. And the complaint alleges that JAM accessed data that can be used to commit identity theft. And in a TIAS, a data breach case similar to this one, the DC Circuit inferred theft and a future risk of misuse based on similar access language, because the court there presumed the purpose of an intrusion into sensitive information is to at some point.
Counsel, let me interrupt you there, but just because you brought up the purpose of the intrusion, is it not relevant here that the purpose of the intrusion was not necessarily identity theft, stealing the data, but rather to hold it ransom? And that in fact, that purpose was met by the payment of the ransom. What do we make of that?
Your Honor, we construe the purpose of the hackers as being financially motivated in general, which asking for and receiving that ransom payment certainly speaks to. However, given that this party is financially motivated, it doesn't really stretch the imagination to think that they might misuse the data that they accessed, and as we are arguing, that they have also stolen.
But as my colleague, Judge Restrepo has just mentioned, there's been no indication that in fact that data has been used, and that's different than some of the other cases that you rely on.
Well, Your Honor, there is no actual misuse requirement in the other data breach cases, generally speaking, in at least the 7 circuit court cases that have considered the standing question in data breach cases. And we point again to the TIAS case in the DC Circuit, which conferred standing despite no other misuse. And they, again, keyed in on the allegation that sensitive information was exposed, and the sensitive information had also not yet been stolen in that case.
Counsel, how do you deal with Clapper, though, which requires that when the injury has not yet happened, which you have indicated is the case, that the harm, the impending future harm has to be certainly impending?
Yes, Your Honor. Clapper requires not just that the harm is certainly impending, but the test looks at the number of inferences and looks at how attenuated those inferences are. And here we're really just asking the court to infer that JAM stole and will misuse T&B user data. And we point particularly to the facts that speak to that issue. And despite the fact that Ms. Mendel has not had a chance for discovery, the facts support that inference of theft, particularly that T&B lost control of and access to its own servers with data on it for nearly 24 hours. And during this time frame, JAM said that they stole a copy of the data and had transferred it to their own servers. And T&B eventually paid the $500,000 ransom because they found this threat credible enough. And prior to this litigation, T&B had not taken a clear stance on whether or not data had been stolen. As a customer service rep told Ms. Mendel over the phone, quote, "For all we know, your information may not have been compromised, but it also may have been." And the facts also support the inference that JAM will misuse the data. JAM again said they would misuse the data unless they received the ransom payment. And the fact that they were—
But again, it circles back to my earlier question to you. The ransom was paid and nothing has happened to the breach with respect to any data that was maybe taken. We don't even know if the data was taken, do we?
We do not, Your Honor. And to that question, we point to the substantial risk standard and how the other circuits have applied it in standing cases with data breaches involved. And there is actually a consensus among the circuits that a data breach poses a substantial risk of future harm, despite any sort of misuse or despite any actual harm already occurring, where 1, the breach exposed sensitive information, and 2, the hackers had malicious intent. And here, the breach exposed not just an email address or Ms. Mendel's first name and last name. It exposed her credit card number, social security number, and other information from her extensive background check. And all of these things can be used to commit identity theft or financial fraud. And in terms of malicious intent, we have a clearly bad—
Wouldn't the remedy then be to pursue a claim against somebody that used this data as opposed to speculating that somebody might use the data?
There are 2 reasons why we bring this claim against T&B. The first is that Ms. Mendel entrusted her highly sensitive data to T&B, and T&B used it for their own monetary gain. It's key to their business model that they have this kind of sensitive information for their algorithm matching. And the second reason why we brought the claim against T&B is that they're a defendant that could much more easily be hailed into court than JAM could be. And going back to the malicious intent, we emphasize that GM threatened to commit identity theft with the sensitive information of nearly 100 million people and held the data ransom for the payment. And as we've already touched upon, my opposing counsel, Ms. Stonehill, might suggest that this court should not confer standing until another TNB user has experienced identity theft or fraud. And we point to the fact that this case has not yet proceeded to discovery, and it could very well be the case that somebody else has in fact experienced data misuse, and TNB could simply be withholding that information. And it could also incentivize other companies like TNB who experience breaches in the future to withhold that information to win dismissals early on in the pleading stage. GM has already arguably misused the data as well by fraudulently locking TNB out of the database for 24 hours and using that user data to induce and receive that ransom payment. And aside from her claims of future harm, Ms. Mendel has already suffered actual harm in the form of mitigation costs, as we've discussed already. Monsanto made clear that mitigation costs alone can confer standing where there's a substantial risk of future harm. And the risk of identity theft or fraud here does pose a substantial risk for the reasons already discussed, because hackers with malicious intent expose some of Ms. Mendel's most closely held information. It's also not true that Ms. Mendel sought to manufacture standing by incurring these mitigation costs. She took a precaution securing the credit monitoring service that TNB encouraged her to take. And taking this precaution would not have been necessary in the first place had TNB adequately protected its servers. It would also have made a bad situation worse if Ms. Mendel did nothing instead of incurring these mitigation costs. From a personal standpoint, Ms. Mendel was in the middle of a mayoral campaign when this breach occurred, and it was necessary for the sake of that campaign and for the sake of her career as a public figure to detect fraud or identity theft in real time.
Isn't your actual harm argument necessarily tied to the imminent harm argument? In other words, if we disagree with you with respect to the imminent harm argument, do you lose on the actual harm?
That's correct, Your Honor. However, that connection has been pretty loosely held. In Monsanto, the Supreme Court granted standing where they thought that there was a substantial risk of future harm, and that involved predictions about how certain farmers would prefer a certain strain of alfalfa seed and how bee pollination patterns would respond to those farmers' preferences and potentially harm the plaintiffs. And in that case, the plaintiff farmers who would potentially be harmed had not yet taken any sort of precautionary measures, and the court more or less invented precautionary measures that they would have needed to have taken and granted standing on that basis. So it was a much looser basis of standing in Monsanto than it is in this case. And from a legal standpoint, making Ms. Mendel's situation worse by not incurring these mitigation costs. If she simply let time pass until the harm occurred, TNB could argue that any eventual harm was not traceable to the TNB data breach and was potentially traceable to some other data breach. And in that same vein, TNB could also argue down Ms. Mendel's remedy by suggesting that she failed to mitigate avoidable damages. And in conclusion—
Counsel, can we back up? I'm not following your argument right before the last one, that if she hadn't taken the steps, she wouldn't be able to trace it. How, by taking these steps, could she trace it?
By taking these steps, how could she trace the harm?
Right, by taking the mitigation that she did, how does that make it more likely she can trace it?
Yes, Your Honor. It's not the fact that she could trace the harm, but she could detect whether harm was occurring before it had gone from a bad to worse situation. So in the instance that any sort of financial fraud were being committed, she could detect that in real time. Or in the instance that somebody had taken her social security number and opened new bank accounts or opened new credit card lines, then she would have known about that in real time before it became a much bigger problem.
But how does that trace back to this data breach?
I'm sorry, Your Honor. It traces back to this claim. It is, as far as we know, the only recent data breach that Ms. Mendel has experienced, and that fact alone means that any harm stemming from a data breach, any harm related to financial misuse, particularly any harm related to misuse of her social security number, assuming Ms. Mendel is not frequently handing that information out, should be traceable back to the breach of the TNB servers. And in conclusion, Your Honors, Ms. Mendel deserves her day in court. She faces future harms based on the malicious and sophisticated nature of the data breach. This future harm has led her to incur necessary mitigation costs. For these reasons, we respectfully request this court reverse the lower court's dismissal. Thank you.
Thank you, counsel. Next up, we have Ms. Stonehill appearing remotely. Ms. Stonehill, I understand that you do not have a clock in front of you, but Judge Restrepo is going to be roughly timing your 15 minutes using his own iPhone, and he will signal to you when you have approximately 1 minute remaining, okay?
Thank you, Your Honor.
All right, you may proceed.
Your Honors, and may it please the court. My name is EP Stonehill, and today I'm representing the appellee T&B Incorporated on the standing issue. T&B requests that this court affirm the dismissal of Ms. Mendel's negligence claim for lack of standing. The court should find that Ms. Mendel's allegation of a future risk of identity theft is too speculative to constitute an injury in fact for two reasons. The first is that Supreme Court precedent directly supports this exacting approach. And the second is that data breach litigation, unlike the environmental or toxic tort context, does not justify the watering down of Article 3 standing. As my friend,
would you address counsel's argument that damages have been incurred, that some monies were spent and some time was spent to mitigate the risk of a data breach?
Yes, Your Honor.
Does that confer standing?
No, Your Honor, this does not confer standing. Clearly, under Clapper, self-imposed mitigation efforts are not enough to constitute an injury in fact if the future harm is not indeed certainly impending. So where the future harm is speculative, self-imposed mitigation efforts and emotional harms alone are not enough to confer standing. And there the court in Clapper was particularly concerned that plaintiffs would be able to manufacture standing and that this would weaken what is fundamentally a constitutional limiting principle. So
But counsel, in this particular case, what choice did she have? The T&B said they would get this monitoring for them, and it didn't. There was a data breach indeed. Everybody would be concerned about identity theft. So what choice did she really have?
Your Honor, in terms of credit monitoring, the offer of credit monitoring has not been seen as a dispositive admission of guilt or negligence based on the Fourth Circuit's holding in Beck. And that's because a company could offer data mitigation services for a variety of reasons. And it would be against public policy for the court to find that an offer of goodwill and an offer of credit monitoring.
That's not the issue though. The issue is standing. I'm not saying that just because they offered it, they must be responsible. We're talking about whether there is some standing here. She had some damage to her. And you're arguing that her mitigation efforts were not necessary. But your client didn't take the action it said it would take. So what choice did she have?
Your Honor, the argument is not that the mitigation was not necessary, but instead that the mitigation is not enough to justify Article 3 standing under Clapper. And you're right to note
So
that—
what would, suppose she spent $1,000, would that do it?
No, Your Honor, because a plaintiff can't simply repackage their theory of future harm by imposing mitigation efforts. And the threat of future harm must be certainly impending. But to answer the root of the question, which is that the plaintiff here has potentially suffered some actual harm. It is true that something bad has happened. A data breach has occurred. But as opposing counsel, Mr. Bruns noted, nothing bad has yet occurred to the plaintiff. There has been no change in status quo aside from the fact that she's spending $25 on credit monitoring. And that's where this is an extremely different circumstance than environmental and toxic tort litigations, which are the main contexts where the court is willing to use the lesser substantial risk standard and find future harm based on emotional claims alone.
But is the Clapper standard actually really on point here? The court and Clapper seem to be very concerned about separation of powers concerns and the notion that what was at stake there was a request to have the court strike down an act of Congress. That's not what we have going on here. So is Clapper really the appropriate standard to serve as a touchstone in this context?
Yes, Your Honor. Clapper's certainly impending standard is the rule that the Supreme Court uses to judge future harm. And the underlying substantive claim in Clapper did challenge a federal surveillance statute, and separation of powers concerns were indeed more implicated. And the court did frame its holistic decision by saying that they are more reluctant than normal to confer standing where there is a separation of powers concern. But the court in Clapper did not create a new or more exacting standard to use in the national security context. Instead, it reiterated and re-emphasized the standard that the Supreme Court has been using since 1979. And in suggesting that the certainly impending standard is the rule for judging future harm, the court cited 5 cases from a variety of different contexts that did not implicate national security or separation of powers in the same way.
And at the same time, in the footnote, it left alone this substantial risk standard. So help me understand the distinction between the two.
Yes, Your Honor. The footnote in Clapper is admittedly ambiguous. In footnote 5, Clapper suggested that substantial risk is another avenue that a plaintiff can use to show future harm. And the court has clarified in Susan B. Anthony List versus Dryhouse that the substantial risk is indeed a second way that a plaintiff can show that a threat of future harm is imminent, sufficient to constitute an injury in fact. And in the data breach context, both standards have been used by both sides of the circuit split. And so there's even a remaining ambiguity in the data breach context as to how different the standards even are. But considering Supreme Court precedent, the substantial risk standard is generally a lower standard that's reserved for environmental and toxic tort contexts where the threat of future harm is bodily or irreparable. And so there, for instance.
So a question for you. So in your worldview, what sort of damages would confer standing in the data breach? What would have to happen?
Your Honor, for Ms. Mendel to face a certainly impending or a substantial risk of identity theft, she would need to demonstrate misuse stemming from the same breach. And this is the commonality that both sides of the circuit split have found. So for instance, the Seventh Circuit in Ramijas, which is a case actually favorable to my opposing counsel, the court granted standing there because there had been 9,200 instances of misuse stemming from the same breach. And so misuse, if there's any factor that is dispositive, and no factor is, but if there's any factor that's the most salient, it's misuse. And the circuits are extremely reluctant to find standing where there's been no misuse stemming from the same breach. And that's why Ms. Mendel's claim is not certainly impending under Clapper, because there has been no misuse. So the court will need to engage.
How do we know that? Mr. Bruns indicated no discovery has taken place. So we don't know if there's been misuse because nothing's been disclosed.
Your Honor, there are no facts that show that there has been misuse, but there are 100 million monthly users of T&B's service that have also been implicated by the breach and were also offered credit monitoring. So it follows that if misuse had indeed occurred, then it would have been reported. And here, Ms. Mendel shows no facts that there has been misuse. Ms. Mendel cannot even allege that her data has been stolen. So in the first place, the court needs to backtrack.
There has been misuse. I mean, the data was breached and ransom was paid. So there has been misuse of the data, right?
There has been misuse of the data, but only as it has affected T&B. And that question points to an important and subtle distinction between the ransomware context and the data breach context. And Justice Márquez, you posed this question earlier when you mentioned that this is a ransomware attack. And indeed, that is different because in other mass data breaches, it's easier for courts to infer malicious intent to commit identity theft because, as the court in Romijas rhetorically questions, why else would hackers break into a system? But here we have an answer to that rhetorical question. Why else would JAM break into the system? To earn $500,000 from T&B. And so JAM's MO is to commit ransomware attacks. If anything, it would behoove JAM to keep its promise and to indeed not commit identity theft and to not misuse the data so that it can keep earning ransoms from other companies.
Why is that necessarily true? I have trouble following that chain of logic. Once they have the data, what is to stop them from misusing it? It seems that Ms. Mendel's concerns are very legitimate.
Your Honor, your question requires speculation into the mentality of a third party, not before the court. And that's precisely why this chain of inferences is too speculative under Clapper, because here the court would have to inquire as to what is JAM's intent as a hacking organization. But it is different because JAM has promised not to misuse the data. And so if they were to misuse the data, then their whole MO of earning ransoms from companies would be ineffective, because why would companies pay the data if JAM were just to renege on its promise and misuse the data in the first place? And so ransomware attacks are indeed different. But even assuming that JAM does have the intent to commit identity theft, and even assuming that JAM has stolen the data, this is still too speculative under Clapper's standard, because the court would further have to infer that out of 100 million monthly users, that JAM would use Ms. Mendel's data to successfully commit identity theft. And so the court in Beck, the Fourth Circuit, found that it was too attenuated, where the hacking organization would have to choose the plaintiff's data out of thousands of other plaintiffs. Here, it's out of 100 million other monthly users. And so the chain of speculation starts from whether the data was even stolen and goes through a series of inferences that start with the word if. And Riley versus Ceridian Corp, the 2011 Third Circuit decision, said that it is too speculative. A future harm is too speculative if the court can't get from what's happened to the plaintiff's injury without starting with the word if. And here the court has to consistently ask if the data was stolen, if it will be misused. And so under Clapper, Ms. Mendel does not allege a certainly impending risk of future identity theft. But even under the substantial risk test, which is the lesser standard that Mr. Bruns suggests the court should use, Ms. Mendel still does not allege a substantial risk of future identity theft. And that's again because she has alleged no misuse. And moreover, it's also because there's no malicious intent to commit identity theft. And here is where it is ambiguous in the data breach context just how different the certainly impending versus the substantial risk standards are, because in both cases, the court is considering malicious intent and is considering misuse as it determines whether a threat of future harm is sufficiently imminent to constitute an injury in fact. In any event, the 14th Circuit should use Clapper's certainly impending standard because the data breach context does not justify the watering down of Article 3 standing. If the court were to grant standing for Ms. Mendel, then there would be no limiting principle. All 100 million other monthly users of T&B would have standing to sue in federal court for $1.85 million. And this is a watering down of a constitutional limiting principle. So under Mr. Bruns's suggested ruling, then practically every citizen in America would have standing to sue in federal court because data breaches are so common. And here,
Ms. Adopt your position, then nobody would have standing.
No, Your Honor, plaintiffs would have standing when they can allege misuse stemming from the same data breach. And in fact, that outcome is extremely common in circuit court decisions. For instance, the Northern District of California and RayZappos.com litigation found that because there was misuse stemming from the same breach, that every plaintiff who had been affected had standing to sue. So there would still be standing to
Let
sue.
me squeeze in a quick question before your time runs out. I'm concerned about the fairly traceable component of standing. If you force a plaintiff to wait until actual harm occurs, doesn't that end up hurting them in showing the traceability back to the original breach?
Your Honor, that the premise of that question is speculative, because what if the identity theft never happens? Then fairly traceable is also not at issue. And also, with all due respect, fairly traceable is going to be at issue no matter what in data breach litigation, because that's the second part of the conjunctive standing test. And so a defendant is always going to try to argue that the conduct is not fairly traceable just by the nature and the anonymous nature of hacking organizations. I see that I'm out of time. May I briefly conclude?
Please.
Team B respectfully requests that this court affirm the dismissal of Ms. Mendel's negligence claim for lack of standing. Thank you.
Thank you. All right, we will proceed now to issue, I'm sorry, we have some rebuttal time. And Mr. Bruns, can you let the court know how much time you have left on your clock, just so we have a sense of what you have left?
Yes, Your Honor. I have 2 minutes left for rebuttal.
Terrific, thanks. You may proceed.
Thank you, and I'll be brief. I'd just like to address one point that Ms. Stonehill made in her argument, and she brought up concerns about judicial economy and that allowing standing here could water down the Article 3 standard. But we emphasize that this is not your run-of-the-mill data breach. It was one of the biggest ransomware attacks in history that involved the records of 100 million people. And as we mentioned in the main argument, it involved the hackers accessing highly sensitive information that's not accessed in your run-of-the-mill data breach.
So
and
isn't the proverbial floodgates that 100 million people could bring the exact same lawsuit just because they're afraid their data was breached?
I'm sorry, Your Honor, I didn't hear the first part of your question. I apologize.
Isn't this the proverbial floodgates argument that if we accept your position, then 100 million people file lawsuits just because they fear that maybe their data was breached?
That's true, Your Honor. 100 million people could certainly file a lawsuit arising from this data breach. However, the court can efficiently manage that lawsuit by certifying the 100 million, or probably a large majority of them, as a class. The only reason why Ms. Mendel is not proceeding as a member of a class is that she has those particularized harms as a public figure and the emotional distress that she experienced. And we also emphasize that the proposed standard we have set forth is limiting. If we were to apply it in the 4 data breach standing cases that have not conferred standing, it would not disturb those decisions whatsoever. And as a policy matter, we point to the fact that T&B has profited off of using sensitive information for their algorithm purposes, for their matching purposes. And it seems only fair that they have to internalize the costs of their misuse and mishandling of that data. And for these reasons and others, Your Honors, we respectfully request this court reverse the lower court's dismissal. Thank you.
The court thanks both counsel for their excellent arguments. And at this point, we will now proceed to issue 2. And according to my sheet, Ms. Rodriguez will be arguing first for the appellant. Thank you, Ms. Rodriguez. You may proceed.
Your Honors, and may it please the court. My name is Patricia Rodriguez, and I will be addressing whether state law governs the interpretation of a forum selection clause. With the court's permission, I would like to reserve 2 minutes for rebuttal.
You may.
I will highlight 3 main points. First, because contract interpretation is a substantive issue, applying Eagleton law to the interpretation of this forum selection clause is consistent with the twin aims of Erie. Second, the accident of diversity jurisdiction should not change the applicable substantive law absent congressional authorization. And third, under forum nonconvenience, the balance of factors weigh in favor of Ms. Mendel. Therefore, Ms. Mendel respectfully requests that this court reverse the 12B3 motion to dismiss for forum nonconvenience. Before reaching any issues of enforceability of this forum selection clause or reaching any balancing of factors under forum nonconvenience, this court should first interpret this forum selection clause using Eagleton law. And because Eagleton law renders this clause not valid, then the issue of enforceability is not reached. This is
Let me
because
dive in with the first and probably obvious question. Aren't issues of forum really procedural issues that ought to be governed by federal law? Why should we be looking to state law to interpret this forum selection clause?
Your Honor, a forum selection clause is two things. It's first a contractual provision, and it's also a mode of how the court should proceed with this litigation. The contractual provision is the substantive arm of a forum selection clause, and therefore that falls under state law, state contract law. And then the how the litigation will proceed is the enforceability arm, which is the procedural part. That's where federal law applies in this case. This is because interpretation is analytically distinct from enforceability. And only after a court has resolved the issues related to interpretation does enforceability come into play. And as mentioned just now, in federal courts, federal law applies to the enforcement of that forum selection clause. But typically, questions of contractual interpretation has been the realm of the states because it is quintessentially substantive for Erie purposes. To hold otherwise would let companies like TMB effectively game the system. It would mean that a corporation can simply undermine state law and leave an individual like Ms. Mendel no choice but to file in a foreign jurisdiction where she has no contacts or not file her lawsuit at all and not get any justice.
Your colleague has brought to our attention that your client is an up-and-coming politician, a very sophisticated person. She signed the contract, didn't she?
She did sign the contract, Your Honor.
And there was a discussion of the contract with the representative of the company, correct?
That's right, Your Honor.
So why shouldn't we defer to the contract that she voluntarily signed?
Your Honor, in this case, Ms. Mendel is not contesting that the contract in general is not valid. The contract is valid. However, this one forum selection clause is not valid because under Eagleton law, it says that if the clause does not appear on the first page, if it's not preceded by bold headings, or if it's not made clearly apparent to the party that this clause is there, then the clause is not valid. And this is a choice by a democratically elected Eagleton legislature that they carefully crafted this law to make sure that their citizens knew that they were signing a forum selection clause.
She knew because she discussed it with the representative. It's not like she didn't know she was signing this.
She discussed the rest of it.
She discussed this very provision with the representative. He may have dismissed it as legal mumbo jumbo, but she discussed this very provision with the representative. So she can't say she wasn't aware of it.
Your Honor, in this case, the law says that the party has to be made sufficiently aware of the clause and not as legal mumbo jumbo. And there are many reasons why Eagleton drafted this law, and it's because they want to protect their citizens from this case, being held into a foreign court where they have absolutely no contacts with. Now, while it is true that freedom of contract is important and respecting the will of the contracting parties is important, all of those are subject to limitations that states are well within their right to enact. Now, it also would undermine the twin aims of Erie to use state law to interpret, federal law to interpret this forum selection clause. It would encourage forum shopping because it means that a company like TMB can simply remove a case to federal court and skirt state laws. Or And it's also an inequitable administration of the law because non-citizens in a forum all of a sudden would get the benefit of federal judge-made law, while citizens in the same forum have to comply with those state laws. The accident of diversity jurisdiction should not mean that a different set of law applies, and this is precisely what Erie was trying to avoid. Also, a forum selection clause can involve a lot of different issues. For example, whether to admit parole evidence, construing vague terms, the scope of a clause, whether the clause is mandatory or permissive, and whether the clause is valid. Issues of validity go to whether a clause comply with all required formalities and whether it comply with state law. And for a federal judge to start applying federal law to interpret this one clause that, again, can involve a lot of different issues, it would start creating a sprawling federal common contract law. And under Erie, there is no federal common law. Also, there is no justification why to allow two different sets of law to apply to a single contract. That may not only be confusing for courts to apply, it would be inconsistent and it could yield dissimilar results. Now on to the issue of diversity jurisdiction. Under diversity jurisdiction, state law applies unless it involves unique federal interests related to restricted areas or unless Congress has spoken on the issue. And we have neither in this case. First, this is a contract between two private parties. It does not involve these restricted areas that, for example, Admiralty is. And Congress has not spoken to preempt this in any way. There is not a Forum Selection Act, there is not a Federal Contract Act, and Section 1404A of the Federal Rules of Civil Procedure does not fill this gap. According to the Supreme Court, 1404A is merely a federal housekeeping measure. It does not justify that one might get a change of law as a bonus of getting a change in venue. And it's also a fundamentally different procedural mechanism. It governs a narrow subset of cases involving the transfer from one federal court to another federal court. The Supreme Court has said that it requires a lesser showing of convenience, and it's not as harsh of a consequence that forum nonconvenience is. It does not require a dismissal. And that brings me exactly to forum nonconvenience. Under forum nonconvenience, several factors are weighed, including public factors, private factors, the availability of an alternative adequate forum, and the deference required to a plaintiff's choice of forum. And here, starting on the public factors, as noted, the consequences of granting a motion under forum nonconvenience means outright dismissal. It means that Ms. Mendel will have to start all over again in a new jurisdiction in a foreign country that she has no contacts with other than this invalid forum selection clause. And that has huge consequences because, for example, the record is depleted of any information about what remedy, if any, Ms. Mendel would be able to obtain. And even if she were able to prevail, would she, as an individual, be able to enforce a judgment in a foreign country? Much less US courts may not be willing to enforce a foreign judgment, and that area is extremely unpredictable. So the federal interest should weigh in favor of maintaining the current forum because otherwise their citizens would be hailed into a foreign court that does not represent them. And also, if a federal court were to
Let me backtrack a bit. Are we in a position to review this issue on this record?
I'm sorry, Your Honor, could you please rephrase your question?
Are we in a position to reach this issue on this record? And all we have is the complaint and some references to the legal mumbo jumbo. But shouldn't we let this go to discovery and determine what her understanding was of this contract?
Well, respectfully, no, Your Honor, because it's a little bit of two different issues. One is first the threshold issue to determine where this lawsuit will take place. And after a forum is selected, whether there was a breach. And in the case of a breach, she would be able to say that she is aware of the rest of the contract. But as far as the forum selection clause, then that issue would have been resolved before reaching discovery. And moreover, on the public factors, what is keeping corporations from assigning foreign jurisdictions in all their future contracts if courts are willing to enforce and say that they are valid? That would have a chilling effect on all future plaintiffs and may have terrible consequences. Eagleton also has huge interest.
You're not arguing that forum selection clauses should not be part of contracts, are you?
No, Your Honor. And in fact, looking at the Eagleton law, it does not say that forum selection clauses are invalid. It's a very reasonable law that has 3 different options when a forum selection clause could be valid. And TMB could have easily looked in these, in the laws of Eagleton and complied with them pretty easily without too many transactional costs.
Does TMB do we know whether TMB works in other jurisdictions? I mean, are you putting a lot of onus on TMB to have to search and research local laws to make sure that they comply with them across the board?
Well, Your Honor, TMB has over 100 million users and they are a corporation. So they likely do business in other states. I would argue that doing some due diligence is less costly than going through litigation. And also—
Are you suggesting they need to modify their contracts for every jurisdiction where they do business, as opposed to having the same rules for all of their 100 million users?
Well, practically they can modify their contract for the most stringent jurisdiction and cover all their bases. And in conclusion, we ask that this court reverse the 12B3 motion to dismiss for forum nonconvenience. Thank you, Your Honors.
Thank you. Next, we have Ms. Aurora Lee arguing for Appellee. Ms. Lee, you may proceed when you're ready.
Thank you.
Your Honors, may it please the court. My name is Aurora Lee, and I represent TMB on the second issue regarding forum nonconvenience. On this issue, we ask that you affirm lower court's decision to dismiss and hold that federal law applies, rendering the forum selection clause enforceable. There are 3 reasons to affirm. First, this is a procedural issue, and federal law ought to apply. Second, the Supreme Court has consistently upheld forum selection clauses. And third, public policy interests strongly weigh in favor of using federal law to render this forum selection clause enforceable. There are a few facts to keep top of mind while considering the law in this case. Ms. Mendel and TMB came into this contract voluntarily. Ms. Mendel has also already stated that it is a valid and enforceable contract. Turning to the law, when a case arises in diversity in federal courts, the federal court must decide where to apply state law and federal law. The Erie Doctrine and its progeny give guidance on this issue, and in Hannah v. Plumer, the court held that where substantive issues are at issue, then state law ought to apply. However, when federal procedures are the matter of the case, federal law, when procedural matters are at issue, then federal law ought to apply. Here, this is about a procedural issue. The courts have called rules regarding fora selection to be federal judicial housekeeping measures. When Justice Marshall said that, he was referring to forum nonconvenience issues and rules regarding the selection of fora for the federal courts. It's clear that the Supreme Court considers these rules to be procedural in nature. In Hannah v. Plumer, the court also held that when Congress has spoken on an issue, federal law should apply. Here, the forum nonconvenience doctrine has been largely codified in 28 U.S.C. 1404a. This is a holding that Justice Alito announced in Atlantic Marine, and it says that forum nonconvenience and the federal court's ability to transfer under 1404a are the same doctrine, and that means that the Congress has already spoken on this issue, and so federal law should definitely apply. Finally, in Byrd v. Blue Ridge, the court held that when state interests and federal interests are at issue, they should be balanced, and that whichever the state or federal interests weigh more heavily that type of law should be applied. And that is the case when Congress has not spoken on an issue. So if you're to take the opinion that Congress has not spoken on this issue, then state and federal interests ought to be weighed. Here, federal interests such as promoting the freedom of contract, protecting the freedom of contract, promoting judicial economy, and preventing gamesmanship via forum shopping all point in favor of using federal law to interpret this forum selection clause and therefore holding it to be enforceable.
Counsel, in this case, however, T&B really is the big player. And they didn't choose a state that is in the United, they chose a foreign jurisdiction, and they pretty much impose that on all of their members. So why should we enforce a clause that seems so unfair?
Well, Your Honor, it's the plaintiff's duty in this case to actually bring forward facts that show that it is unreasonable. However, in terms of T&B, they're incorporated in Alethea. This is where they chose to litigate their matters. In terms of the contract that was given to Ms. Mendel, there in the letter that she was given, she was asked to read through the entire contract before signing. She obviously read through parts of the contract because she called someone with questions, but then when they said, call back if you have additional questions, she did not call back and did not engage with T&B again. She was given plenty of notice that this forum selection clause existed due to primacy and recency factors in the mind, because the forum selection clause is the last thing on the page that she signed, so she certainly flipped to this page. It should be clear that she read these 24 words that say very clearly that all disputes arising out of this should be litigated in the general jurisdiction of Alethea Agape. And so T&B's choice of Alethea is not exactly a question here. The plaintiff hasn't brought forward any mitigating factors that say that justice could not be acquired in Agape, and that is her burden because there is a forum selection clause. The appellee here does not carry a burden to show that the pre-selected forum is unreasonable. It is only up to the breaching party to show that the pre-selected forum is unreasonable.
What do we make of the comments attributed to your client's representative who said that the forum selection clause was just legal mumbo jumbo and very dismissive, and in essence told her to disregard it?
Well, Your Honor, we would disagree that he told her to disregard it. He actually said that it is something that is found in every contract. And while he did call it legal mumbo jumbo, this is a silly phrase. It's unfortunate that he used it and came away with a different meaning than Ms. Mendel, who may have decided that this was worth dismissing. However, the representative did not outright tell her to dismiss this issue. He said it's in every contract. Perhaps he thought that that meant you should definitely read these 400 words that will take you a minute and a half to read. And so it's an unfortunate set of facts for T&B that he used that language. However, it doesn't change anything in terms of the notice that Ms. Mendel was given. Additionally, within the contract, it says that it is a fully integrated contract and that no written or oral conversations contemporaneous with the contract can affect the actual written agreement that she is signing. And so even if she were to claim that this oral agreement that she had with the representative impacted her understanding, she was given notice within the contract that it did not have any bearing on the actual binding negotiation that she was signing and confirming herself to. Turning to Supreme Court precedent, the Supreme Court has consistently upheld forum selection clauses. They are presumptively valid in the Supreme Court, And this shows a strong federal interest in finding forum selection clauses to be valid. This means that it would be inappropriate.
Counsel, let me take you just a step back before we get into the enforceability. I think you would agree that there's a distinction between the interpretation and the enforceability, correct?
There is in this case, Your Honor. However, the Supreme Court has declined to bifurcate the issue.
Would you not, though, agree that in terms of the interpretation, what we're doing is we're interpreting a contract, and isn't the interpretation of contract generally substantive law that would fall on the state side of the ledger for purposes of the Erie Doctrine?
Yes, Your Honor. However, because of the strong federal interest in finding it enforceable, you also need to consider that it would be inappropriate for a state to be allowed to contravene that federal interest. And so the public policy interests in this case weigh towards using federal law to prevent states from contravening that federal interest. And in the Bremen case, the court said that forum selection clauses are presumptively valid unless found to be unreasonable, unfair, or unjust. And so the Supreme Court's precedent is to lump together interpretation and enforcement. The only Supreme Court dicta that exists in terms of bifurcating this issue to be enforcement and interpretation exists in a dissent from 30 years ago. And so there's no other indications from the highest court that this is an issue that they plan to take up. Instead, federal law has been applied at that level and should continue to be applied in the circuit court level.
Well, wouldn't we effectively be immunizing your client from litigation if we were to accept your theory here? I can't imagine any of the 100 million some odd users opting to go to a foreign jurisdiction to litigate this.
No, Your Honor, TNB would not be immunized from litigation because Ms. Mendel and the 100 million other users are perfectly welcome to go to the pre-selected forum that they agreed to already litigate these issues in and go to Agape and file there. There's nothing in the forum selection clause or the contract as a whole that would actually change the merits of the case. TNB would need to win in whatever jurisdiction in Alethea it was taken to. And so additionally, Ms. Mendel or any of the other users, or Ms. Mendel here, has not provided any facts in the record to show that this would be a burden on her. In fact, courts have seen that because she agreed to this beforehand, any burdens are actually foreseeable. She should have known that it might be costly to litigate or inconvenient to litigate in a different jurisdiction. And she still signed this contract, even knowing that Alethea was a different country and she may have to litigate elsewhere. So turning to the Supreme Court's consistency, they have also sent these types of cases to foreign jurisdictions before, and the remedy for forum nonconvenience when the appropriate forum is abroad is outright dismissal. The Supreme Court has dismissed cases that were filed in Texas and in Florida to the United Kingdom. Additionally, circuit courts have consistently dismissed these cases as well. In the Ninth Circuit, they have dismissed a case from California to Italy. And so there's no jurisprudence to say that justice acquired abroad is any different than justice acquired in the United States. And the court declines to take that view. So Ms. Mendel still has an opportunity to achieve justice in Alethea, which is where she agreed to prior to the breach of contract that she is claiming. Moving on, if you were to get to the enforceability aspect of this question, it's clear that this forum selection clause would be enforceable because the breaching party here has such a burden. She needs to show that it was unreasonable or unjust or unfair for her to be going to this forum. And private interests in this case completely drop out of the equation. And so Ms. Mendel would not be able to plead facts that relate to cost or convenience. It's only public interest factors that weigh here. As mentioned, the federal interest of finding forum selection clauses to be enforceable is clearly weighs in favor of using federal law and finding the forum selection clause to be enforceable. There are additional public policy interests that weigh in favor of enforcing this via federal law. These include the prevention of gamesmanship. In Atlantic Marine, the court disavowed this and said that it was inappropriate for the party who agreed to litigate in Virginia to then bring a claim in Texas. And so to avoid giving a reward to a breaching party, they applied Virginian laws, the laws of the pre-selected forum. And so here, even if you were to use state law to interpret this clause, It should be the state law of Alethea and not the state law of Eagleton that holds for the interpretation. That's because this is the state law that these parties have agreed to before litigation happened and before any claims were brought.
So does it make a difference that this isn't necessarily an arm's length negotiated contract? This sounds like a standard contract handed out to every user of T&B. Did Ms. Mendel have any opportunity to negotiate this particular provision?
Because this is a form contract, Ms. Mendel could have annotated it herself and signed, and perhaps T&B could have negotiated from there. Form contracts are presumptively valid and enforceable unless they can be shown to be unconscionable. And in that case, she would need to show that the drafting party had unreasonably favored themselves. So in this case, T&B will still need to win their case on the merits, and there's no indications in the agreement that they have unreasonably created terms for themselves. Additionally, she would need to show that there was a lack of meaningful choice. And here, Ms. Mendel signed this contract and then purchased her own credit monitoring service. She didn't have a gun to her head. She didn't need to necessarily sign for this discounted thank you from T&B. She chose to sign it because she wanted to get a bargain. And so in this case, she didn't lack a meaningful choice. She came voluntarily. And so this form contract is completely enforceable against Ms. Mendel, or against T&B on behalf of Ms. Mendel. Additionally, besides the gamesmanship element that is the court has a public policy against, there's also generally the protection of the freedom of contract. There is, Ms. Rodriguez mentioned that states are under their purview to limit contracts and to create a limiting principle there. However, that is not the rule. The general rule, as announced by the Supreme Court in West Coast Hotel, is that the general rule is freedom of contract. It is the restriction is the exception. And so in terms of a person litigating on a forum selection clause, this isn't a unusual case or something that begs to be restricted. In West Coast Hotel, it was minimum wage laws that were being challenged, and the court held that it was appropriate for states to be creating minimum wage laws. Here, this is a relatively routine and innocuous kind of breach of contract, and so it's not necessarily appropriate for states to be creating restrictions to the freedom of contract here. Finally, there's a judicial economy element to this. Justice Kennedy in his concurrence in Stewart said that it is important and it's to be strived for to create a uniformity between state and judicial outcomes across both state and judicial, and then across judicial courthouses within the federal court system. And so here, what Appellant is asking is that in your own jurisdiction, which has different states in your circuit, that maybe Eagleton law applies in some state and another state's law will apply in others. Some are more favorable to forum selection clauses, some are less favorable. And it's unclear how a party could go into these negotiations and draft these contracts when they're not sure where their plaintiff is going to bring the case against them and how they're going to use those states' rules to their advantage. For these reasons, we ask that you affirm the lower court's decision and hold that forum nonconvenience applies to dismiss this case. Thank you.
Thank you, counsel. And we have a couple minutes left of rebuttal from Ms. Rodriguez.
Justice Márquez, I would like to address your question about lumping together the interpretation and enforceability. The Supreme Court has touched on the issue in Atlantic Marine. In that case, it said that federal courts apply federal law to enforce a valid forum selection clause. And that's important because the court in that case was presupposing throughout its analysis a valid forum selection clause. And indeed, it explicitly said in footnote 5 that it was presupposing such clause was valid. It did not address how to determine whether a clause was valid. It did not address whether it was presumptively valid. It just left that issue open. But what's important about this is that in terms of enforceability, this case would be unprecedented to grant a dismissal. For example, in Bremen, that involved two companies that did an arms-to-arms length negotiation and chose and bargained for a specific forum. They did business internationally. When there have been individuals getting dismissed for forum nonconvenience, like Papas, for example, the injury there occurred in the Bahamas. All the witnesses were in the Bahamas, and they had traveled to the Bahamas. Here, Ms. Mendel did not travel to Agape to sign this contract. She mailed it from Eagleton. None of this case has involved Agape other than the TMB being headquarters there. So in conclusion, because using state law to interpret this forum selection clause is consistent with Erie, and the balance of factors favor Ms. Mendel, we respectfully request that this court reverse the 12B3 motion to dismiss for forum nonconvenience. Thank you, Your Honors.
Thank you. The court thanks both counsel for their excellent arguments. The court is going to take this case under advisement. We are going to move to a different Zoom room to deliberate, and we will rejoin you in a few minutes.
So Justice Márquez, which room are we moving to?
We go back to the original room.
If you go to the chat, you'll see the most recent posting. There's a link.
Okay, I see it. All right, thank you.
Okay, hi everyone. While our judges go deliberate, we're gonna have a little bit of a Q&A with our finalists here. So that way you guys can ask them any questions you have about moot court or Rothgerber or their experience or anything like that. So I think I speak for everyone when we say we're super proud of our finalists and everyone did an absolutely amazing job today. It's really hard to go up in front of real judges for the first time. They've just been judged by 3Ls up until now. So they've been working incredibly hard for the last month. Virtual round of applause for them. But yeah, so now whatever questions you have, just send them in and I can ask them to all four of our finalists here. Okay, well, yes. Okay, first one. Okay, so everyone will answer. How did you guys get started in moot court?
I started technically with CAC this year, but last year I was in the same section actually with EP and Patricia, and we had Professor Hall, and we had our 1L oral arguments, and that was super fun. I actually argued against Patricia last year, so I just can't shake her. She's really awesome. And so that was such a fun experience that I knew I wanted to try out for CAC in the fall.
Yeah, I'd say pretty much same story for me. I had Professor Bruce 1L, and I thought it was a really fun experience. And I ended up taking advanced appellate advocacy with her last fall, and that was also fun. We did CAC and then did this. So yeah, just little steps.
Same here. I was in Professor Hall section and with Steve in advanced appellate advocacy. And when I did oral arguments, I thought it wasn't as bad as it looked or it sounded. So I figured I'd give it a try into a year.
And I also got my start thanks to Professor Hall forcing us to do an oral argument in our 1L spring. And I remember Asia Robbins, who won last year's Rothgerber, was one of my judges. And she said, hey, you should consider this. And then I was lucky enough to have a friend like Aurora who said, hey, let's partner up and do this to force me to get over my nerves to get started. So it took great legal writing professors and great classmates as well.
Great, thanks guys. Okay, so our next question is, how do you anticipate the hypotheticals that judges will pose?
I think that's where a lot of practice comes in, because our 3L judges are amazing and cruel and throw a lot of hypotheticals at us. And so I definitely had to stumble in a bunch of practices to think about the hypotheticals, and it was great.
Yeah, I agree with that. The 3L judges were really good throwing tough questions at us. The other thing that actually helps a lot too is before starting the research, looking at like a few law review articles, because they kind of like explore the issue more freely than case law does. So those are super helpful.
Patricia, speak up a little bit. Last time they couldn't hear you.
Yeah, and I agree with Aurora and Steve. But also, it's good to really read cases that are against you, because judges are not going to ask questions in a vacuum. They usually look at a non-favorable case and draw things from there.
Okay. Oh, sorry, EP, go ahead.
That's okay. I don't have much new to add, but yeah, practicing with professors was especially helpful. Professor Bloom posed a hypothetical about like a nuclear power plant, and I've been thinking about power plants for like a week because of Professor Bloom. So the more practice with more different people is the best.
Okay, our next question is about preparing for oral argument. So what do you guys do to get started and kind of outline and all of that?
Do you want to do it in order?
Yeah, just listen.
In terms of outlining, we had to write our briefs first, which is an incredible help, at least for me. So I went through when I was preparing for my oral argument and went through my own brief and kind of like took my thesis sentences from my different issues and then decided which ones were important and which ones aren't, because in an oral argument, you don't get to everything in your brief. So I think that after pulling out the top level stuff, I was able to organize how I wanted my outline for like my roadmap to go. But definitely starting with the brief is the most helpful thing for me.
Steve, try and speak up too.
Okay. Yeah, I actually used Professor Bruce's manila folder method, and you kind of paste like your intro on the front, and then Neil actually suggested that when we do these things, trying to like have maybe 3 or possibly 4 major points you're trying to make, so those are all kind of on the inside, and then the backside is like crazy scratchings of potential questions and answers and stuff like that.
Yeah, I start like Aurora with the strongest arguments, but also you kind of have to address the most controversial, because that's the one you're going to get asked about. So if you put it up first, then you may have time to get through the rest of your argument toward. Is this working? Oh. Towards the end of your argument.
Yeah, I think the more time you spend writing the brief initially just really helps you in terms of presenting a good oral argument, because I think that's where most of the thinking happens. But I've also just been like muttering my roadmap to myself for also the last month. So like people in aisle 5 of King Soopers think I'm crazy for talking about standing when I'm getting cereal, but it's just a matter of repetition as well.
Okay, next question. What do you appreciate the most about your moot court teammates?
Everyone's so smart, and it's just really encouraging and energizing, especially being in this virtual world right now. It can be hard to connect and remember what law school's like. Like we got to experience part of 1L in person, and it's a vibe. And so it's been great having moot court team members to, I don't know, just be like in awe of, because I think that that's probably something that would normally happen when I was in person in law school, and it's a little harder right now.
Yeah, I agree with that. I think from all the finalists and all the 3L judges, like there are certain things that you pick up from people when they kind of talk in their moot way, and like even things as small as like how to properly begin a response to a question, like starting like Patricia's really good with like respectfully no and yes and getting straight to the point. So it's like a very collaborative learning type of dynamic.
Yeah, and I think this working? Okay. And I think that you get to meet some of the upperclassmen, like the 3Ls, and they know a lot, and you can learn a lot from them. And yeah, it's just a good thing to do other than just the repetitious law school classes that you have to read. You're actually doing something and applying it and getting it better and like doing it again. So I like it.
I remember when I was applying to CU, it like seemed like a trope that everyone said that it's not cutthroat, it's really collaborative, and I was like, all right, I'll see when I get there. But doing moot court like truly made me believe that that's the reality. I remember emailing Steve, who was like technically my opponent, if he could share a case with me, and he did it in no time. And so it was just like a really positive experience with my competitors who were also my teammates.
Okay, thank you guys so much. It looks like our judges are coming back to give their results. Thank you all for coming again. And if you have there's some questions in the chat just about how moot court works at CU. There will definitely be info sessions in the fall, in the spring, later in the spring from next year's board. And feel free to email me at any time or email anyone involved in moot court, and we'd be happy to answer your questions. But now I'm going to turn it back over to our judges who have so kindly helped us out today.
I think we're waiting on one of our judges to return still.
Okay. I'm on here, but I don't see the other two judges. Am I in the right room?
Yes, you are in the right room.
Okay,
And you used the link that I sent, right?
right.
Okay, I just want to make sure I didn't send the wrong link.
Yeah, no, I use that link, so.
Okay, great. Maybe I'll hop back over to the other Zoom room just to make sure they're not still in there.
There we go. All right, it should be. Yes, sorry about that. I got one of my kids come help me out. I apologize. Can you guys hear me? Oh, good. Okay. Sorry about that.
Okay, so I think now we can turn it over to our judges to announce the best oralist, the winning team, and to give our competitors some feedback. Thank you.
So I want to thank everyone for participating in this competition. I know how much time and effort, how many hours and late nights and just all the stress and agony that you guys go through to put on a competition like this. So I want to commend you all for your tireless efforts and for your excellent job today. Judge Arguello and Judge Restrepo and I talked about it. We had, frankly, a very difficult decision to make. This was kind of an odd moot court with the issues being divided the way they were. I think everybody did a fantastic job with the issues that you were handed. What we have decided, though, is that the overall best team was the Appellee team. And our best oralist award goes to EP Stonehill. So congratulations. Y'all did an excellent job. And what we'd like to do next is to provide a little feedback in order of the appearances today. So Mr. Bruns, wanted to just give you a little feedback first. I'll start and then I'll just pass the baton around to Judge Arguello and Judge Restrepo. I want to commend you for staying as poised as you did. I thought you had an excellent command of your arguments. I thought that you responded very naturally to each of the questions. You had a nice way of sort of pivoting right back to your outline in each case. So very, very well done. And let me offer my fellow judges here an opportunity to weigh in as well.
Well, I would just echo that. I think you were very poised. You had good command of the cases. I liked your rebuttal. I think both sides did really well on rebuttal, is to be able to come up and address what needed to be addressed. It's hard for me to give any constructive criticism because you all are so great. I wish that the lawyers who came before me were as prepared as you all were.
Yeah, I would agree. You all did a great job. And one thing I was most impressed with is that all of you answered the questions. I can't tell you how frustrating it is for judges when we ask questions and the lawyers don't answer them. And kudos to all four of you. You all answered every put to you. Impressed by that. And Mr. Bruns, I very much was impressed with your sense of confidence. You were very confident in the way you made the argument without coming across as arrogant. You did a nice job there.
Turning next to Ms. Stonehill. Ms. Stonehill, excellent job, especially trying to do this from a remote setup. I understand you're snowed in Fort Collins, so I'm sure that added to your stress today. You handled that very nicely for what it is worth. One thing or two things I wanted to point out in particular that I thought you handled very well. One of the things that's really difficult in an oral argument, particularly when you're arguing in front of a multi-member panel, is paying attention to when a member of the court has a question. And what's often challenging about that is you're so focused on what you're trying to say, and yet you're trying to also read body language. If someone's leaning forward and wanting to ask a question and so forth. I think that is becoming more difficult in a virtual environment when you're looking at a Hollywood Squares setup like this. You did an exceptional job of paying attention to when each of us wanted to ask a question. You paused and gave us an opportunity to jump in, which I thought was very nice. The other thing I wanted to add was you were asked a question about a discovery issue that I felt kind of wandered perhaps a little bit outside the record, and I thought you ad-libbed quite well in your response to that. So I think you handled all the questions very nicely. Excellent job. Congratulations.
All I would say is you came out a little bit nervous at first, but then you got your footing and I thought you did really well. You had a good response to the too speculative question that was asked. I really liked that response. I will say you all had the stronger of the arguments, so it was a little easier for you all to argue than I think for the appellant. But overall, a very good job, and you were very articulate. You were very poised, and again, you all knew your cases inside and out.
Yeah, Mr. Stonehill, I agree. You did a nice job, and you did a nice job of teaching us. It's unfortunate that judges refer to these conversations as arguments, because what I tell lawyers is you don't come into court with an eye towards arguing with the judges. Come in as a teacher and teach us the law. And you did a nice job of teaching and explaining your position as opposed to arguing with us.
All right, and Ms. Patricia Rodriguez, I thought you did an excellent job road mapping your argument at the very beginning. You gave us a very good, clear sense of where you're going to be going with each of your arguments. I think you had, like with this, I was just commenting to my fellow judges, this forum nonconvenience issue was kind of a little quirky for a moot court competition. So I think you did a very nice job dealing with kind of an obscure and very bizarre issue. So good job with that. I think you did a very nice job on rebuttal as well. What I really appreciated about your rebuttal argument was you stepped right in and picked up on a question that I had asked your opposing counsel. That was a very nice way to use your rebuttal to sort of tie in and make your rebuttal a good use of your time. So good job there.
And Justice Márquez took my comment. I was just going to commend you on your rebuttal. I thought your rebuttal was excellent to really listen to what the judges asked and then to say, let me respond to the question you asked. And I thought that was just excellent.
Yeah, and Ms. Rodriguez, well done. You had the toughest argument. I mean, you argued that piece much better than I could have ever argued it. So you had, you kind of drew the short straw here, but you did a really, really fine job. And again, let me just emphasize the importance of that rebuttal and making it a rebuttal and not going back to your opening argument. You handled it really very well.
All right, and last we have Miss Aurora Lee. Ms. Lee, like your partner, or like your counterpart actually on issue 2, I think you also did a very nice job road mapping at the beginning of your argument, laying out, here are the 3 reasons why I should prevail. And you stuck to that structure for the most part. I think you did a lovely response to our various questions. I don't think I came up with a question that really threw you. You seemed very well prepared to respond substantively to pretty much everything that I asked. So excellent job.
I don't really have a whole lot to add to that, other than I will say one of your nervous habits, I teach trial ad and I used to always talk to the students about their nervous habits. You have a habit of rubbing your hands. And unfortunately with the microphones, it came across pretty clear. So I think that's just one nervous habit that you have to try to set aside. Tell the guys, don't leave change in your pocket because you're always going to jingle it, that sort of thing. But I agree. I thought that your structure of your argument was very well laid out. I could follow that roadmap very clearly. So I think overall you did an excellent job.
Yep, Ms. Lee, I would agree with Justice Márquez. You handled the questions exceptionally well. You're very confident in your delivery. And even with the hypothetical questions we asked you, or and the rationale you used to explain why your position should carry the day, you did it really, really well.
And so I just want to commend everyone once again. I know just how much time and effort it takes to put this all together. You do this on a volunteer basis. I hope that it was a valuable learning experience for each of you. I don't know if any of you has any questions for the 3 of us, but if so, please raise your hand and come to the podium. Otherwise, I will hand it back to Ms. Horowitz.
I'm actually getting some questions from members of the audience about which team won. I know that you said, I believe you said Appellee, but if you
Yes.
don't mind just announcing the student names as well, because I think there's some confusion.
I'm sorry.
That would
So
be great.
the Appellee team was EP Stonehill and Aurora Lee.
Thank you so much. So I guess that concludes our event this evening. And if anybody has any questions, please feel free to ask. We congratulate all of our competitors. They did a fantastic job. And we thank our judges for joining us tonight. I know this has not been easy doing this remotely, but I think we made the best of it. And now we can all say that we've participated in a moot court competition virtually.